A very good evening to my respected seniors and my dear colleagues. Today's webinar has been organized on the direction of the Honorable High Court. It's just concentration on framing of charge and sentencing under the POCSO Act, and with little emphasis on compensation. Due to time restraint and one-way flow, kindly note down the queries if any, and you can send on the WhatsApp group, and the queries already received will be taken during the presentation. So as I have told you that it is with regard to there is a proposition. The appellant was charged of having committed sexual assault and forcible sexual intercourse with his less than 14 years old stepdaughter, which made her pregnant, and he also subjected her to criminal intimidation. He was put on trial, and the charge framed was under sections 354, 376, 506 IPC, read with section 4 of POCSO Act. And this is the charge which was framed that sometimes in the year 2009 to 5th to 6th October 2013 at Delhi, you being the stepfather of the prosecutrix X, aged about 15 years, here the name and details of the same were also mentioned in the charge sheet, had molested her, and thereby you committed an offence punishable under section 354 IPC and within my cognizance. I think all of you must have made out that what is required. Secondly, the second head of the charge is on 1st May 2013 at house number such and such, village such and such, New Delhi, you had committed penetrative sexual assault upon the prosecutrix X, aged about 15 years, and thereby you committed an offence punishable under section 4 of POCSO Act, read with section 376 and within my cognizance. So now, if we come to the first head, chapter 17 of CRPC deals with the charge. We are very well aware of this. Section 211 requires every charge to state the offense with which the accused is charged, if specific name is given to that offense under the law under which it is punishable, and if the law which is creating the offense does not give it any specific name, then the definition of the offense must be stated. And thirdly, if the accused has been previously convicted and is liable to an enhanced punishment due to this conviction, so the fact, date, and place of previous conviction must be stated. Further, section 212 subsection 1 CRPC mandates that the charge must contain such particulars as to the time and place of the alleged offense and the person against whom it was committed, as is reasonably sufficient to give the accused notice of the matter with which he is charged. Section 214 clarifies words used in describing the offense deemed to have been used in sense attached to them respectively by the law. Now, if we come to this charge, here the word, firstly, the name and details of the prosecutrix have been mentioned. As per the settled law and even the Rabin Burman versus State of Sikkim, Manupatra Sikkim 0038 of 2017, they Non-disclosure of identity of the victim has to be maintained at each and every stage. Now, Section 354 does not mention about the word molestation. It is the outraging modesty of the woman, but not the molestation. Then, coming to Section 218, though it requires a separate charge to be framed for every distinct offence. However, the law creates exceptions. 3 offences of the same kind within the space of 12 months, as envisaged under Section 219, subsection 1, can be tried together. Now 219(2) clarifies that the offences are of the same kind when they are punishable with the same amount of punishment under the same section of IPC or of any special or local law. These offences of the same kind, they must be having the nature of the cognate. Then coming to 220, if the acts alleged constitute an offence falling within 2 or more separate definitions of any law in force, for the time being by which offences are defined or punished, the person accused of them may be charged with and tried at one trial for each of such offences. Meaning thereby that if the offence is constituted under Section 376 and 4 or 6 of the POCSO Act, then they can be charged together. But nothing contained in this section shall affect Section 71 of the IPC. We will come to Section 71 in the sentence part. Further, coming to 221, where it is doubtful that what offence has been committed, whether it is the offence of the IPC or the offence of the POCSO, then he has to be charged in alternative with having committed someone of these said offences. So the alternate charge has to be framed. Now coming back to the charge which was framed, here it is the charge of against the accused who committed the offence of outraging the modesty of a girl of 15 years old under Section 354 IPC. But the relevant section of the POCSO Act, the charge has not been framed. Then coming to the another head, it is under Section 4 of the POCSO Act, read with Section 376. It has been held that such charges should not be framed. This under Section 4, it should have been framed separately and in alternative under Section 376. Now, further, she is a girl of 15 years and is the stepdaughter of the accused. And therefore, Section 5, the clauses mentioned under Section 5 also comes into play, and which is punishable under Section 6. So we have to take care whether the offence which is being committed is in the aggravated form or not. Now, these were the facts of the case Gaya Prasad Pal alias Mukesh versus State, 2016, SCC Online Delhi 6214. It has been mentioned here that molested word which has been used, it is not used, it is not defined in the Section 354. It pertains to offence assault of criminal force with intent to outrage modesty of a woman. And therefore, charge should have been specifically with these words. Thereafter, apart from Section 354, the offence under Section 8 is also prima facie made out. And therefore, the offense under section 354 in alternative section 8 and in the second head with regard to 376 in alternate under section 6 of the POCSO Act should have been there. It is mentioned here that section 221 subsection 1 CRPC guides that it is proper that the accused is charged in the alternative with having committed some one of these several offences, which may be proved by bringing home the allegations concerning a single or a series of acts. Similar with the penetrative sexual assault. And though in this case, though alternative charge was not mentioned, but it was 376 read with section 4. It has been held that though ideally the offense under section 376 IPC should have formed the subject matter of a separate alternative charge. The way it is projected in the charge frame, it can still be treated as a charge in the alternative. So Honorable Delhi High Court treated it as the alternative charge, but has held on the other hand that it was not framed ideally. Again, subject to the caution that punishment cannot be meted out both for POCSO offense and the IPC, thereby constituted the offense. We will come to that part that if the alternative charge has been framed, then how the punishment has to be awarded. But this was with regard to the how the charge has to be framed. We have to keep in mind that what offenses under IPC are coexisting under the POCSO Act. I have formed one chart. Now, this section 375 IPC, which came, the definition was amended with effect from 3rd of February 2013. This is the definition of the rape, and this is the definition of penetrative sexual assault under section 3. If we have a broad look, it is almost the same. The missing part is the consent under the POCSO Act. No question of consent or will arise under the POCSO Act. So 375, it is equivalent to section 3 of the POCSO Act. 376 prescribes the punishment that is again with effect from 3rd of February 2013. Shall not be less than 10 years, but which may extend to imprisonment for life and also liable to fine. However, prior to date 16th of August 2019, it was under section 4 that it shall not be less than 7 years, but which may extend to imprisonment for life and shall also be liable to fine. But the offences which have been committed after 16th of August 2019, they, with regard to the punishment, are at par with section 376. Earlier, it was more graver, and now they are equal. Even with regard to 377, on the other hand, section 4 POCSO Act is correlating. Here, may extend to 10 years, but this is more graver. Then coming to section 376, subsection 2, that is whichever is being committed by a police officer, public servant, and now if we go through section 5, there are again many of them which are mentioned under clauses of subsection 2. They are covered under the clauses of section 5. armed forces, management or on staff of a jail, hospital. Then here comes the educational institution. Here comes the word guardian, teacher. Then during the communal or sectoral violence can create almost, but the number is more under Section 5 of the POCSO Act. And if we look into the punishment, then under subsection 376, subsection 2, it is the rigorous imprisonment for a term which shall not be less than 10 years, but which may extend to imprisonment for life, which shall mean imprisonment for the remainder of that person's natural life and to fine. And here, if we correlate with section 6, then again rigorous imprisonment for a term which shall not be less than 20 years, but which may extend to imprisonment for life and shall also mean imprisonment for remainder of that person's natural life. However, this is after 16th of August 2019. Before that, it was at par with this section 376 subsection 2. Now coming to A, where the vegetative state has been caused of the victim, it is not less than 20 years, but may extend to imprisonment for life, that is remainder, and or with death. And here, for women under 12 years of age, 376 AB, not less than 20 years, but which shall mean remainder, natural life, and with fine or with death. Again, subsection 3 of 376, it should not be less than 20 years, but which may extend to imprisonment for life. It is upon the rape upon a woman under 16 years of age. And under section 4, subsection 2, which has been added with effect from 16th August. This is the punishment. Then 376D, if we compare it, it falls under section 6 of the POCSO Act. 376DA, then again under section 6 of the POCSO. 376DB under section 6 of the POCSO. 376E under section 6 of the POCSO. Now, this was with regard to the penetrative sexual assault. Now coming to the sexual harassment. Section 354A. I'm taking the sections which have been mentioned under section 42 of the POCSO Act, that if any of these offenses are there, then how the punishment has to be granted and under which provision the punishment has to be granted. We have done that the charge has to be there in alternative, but with regard to punishment, first coming to the comparative chart, 354A, what I have come across and to my mind, it is sexual assault defined under section 7, punishable under section 8. 354A, only the clause I of subsection 1, that is the physical contact, and here rigorous imprisonment for a term which may extend to 3 years. Here shall not be less than 3 years, but may extend to 5 years. Then coming to 354A, here under subsection 1, clauses 2, 3, 4, they are comparing to section 11 of the POCSO Act again. And the section 11 is punishable under section 12. So this is the comparative chart with regard to 354A, 354B, assault or use of criminal force to women with intent to destroy. It is defined as aggravated sexual assault under section 9, subclause U. Punishment under section 10. Then coming to voyeurism, 353C, it is again section 11, but clause 4. Punishable under section 12. Though this came into effect with 3rd of February 2030, this was since the enforcement of the POCSO Act. Now coming to stalking under section 354D, section 11, clause 4 again, because here is a follows a woman and contacts, here repeatedly or constantly follows. And punishable under section 12. With regard to 509, the sexual harassment, section 11, clause I, and punishable under section 12. So this is the comparative chart with regard to the offences under the IPC and under the POCSO Act. Now coming to the sentence part. Suppose we have framed the charge under section 8 in alternative under section 354A. On the other hand, 376 in alternative with section 4. Now, section 42 of the POCSO Act states where an act or omission constitutes an offence punishable under this act, and also under sections 166A, 354A, B, C, D, 370, 370A, 375, 6, A, AB, B, C, D, DA, DB, E, or 509. These are the sections of which we have done the comparative chart. Then, notwithstanding anything contained in any law, for the time being in force, the offender found guilty of such offence shall be liable to punishment only under this act or under the IPC. Punishment will be only either under the IPC or under the POCSO Act, in which provides for punishment with a greater in degree. This is in contrast to what the law states otherwise, but here it is whichever provides the punishment greater. Though the provisions of this act shall be in addition to and not in derogation of the provisions of any other law for the time being in force, and in case of any inconsistency, the provision of this act shall have overriding effect on the provision of any such law. Now, the problem crops up when the sentence part is same. Sentence for both the alternate offences is same, then can we sentence him in both the offences? Again, the answer is no, as per section 71 of the IPC and read with section 26 of the General Clauses Act 1897. The conviction can be there for both the offences. Rather, it should not be. Suppose the offence is made out under section 376 as well as section 4 of the POCSO Act. It should not be if the girl is less than 18 years, we will convict him under section 4 and acquit him under section 376. It is the conviction under both the offences as the definition part of both the offences is covered. But the difference comes when the punishment is there. Section 42 only states about the punishment, alternate punishment, and not the conviction. So section 71, it states that where anything which is an offense is made up of parts, any of which parts is itself an offense, The offender shall not be punished with the punishment of more than one of such his offences unless it be so expressly provided. The relevant portion for us where anything is an offence falling within two or more separate definitions of any law in force for the time being by which offences are defined or punished. The offender shall not be punished with a more severe punishment than the court which tries him could award for any one of such offences. For any one of such offences. And if we go to section 26, where an act or omission constitutes an offence under two or more enactments, it is under POCSO as well as IPC. The offender shall be liable to be prosecuted and punished under either or any of those enactments, but shall not be liable to be punished twice for the same offense. I think I have been able to make myself clear that all the above sections read with section 42, 42A, I-71 IPC, 26 of the General Clauses Act. The conviction can be there, but the punishment has to be there if it is with the POCSO Act, then only which provides the greater punishment, and that too on the day of commission of the offense, as there has been the major changes, major amendments with effect from 16th of August 2019. So we should not forget that date. All these facts, as I told you, they were picked up from the Gya Prasad Pal. Here, the conviction was there under section 354 and 506, besides section 4 read with section 376. So if we go 376, the accused has been punished to undergo RI for life, to pay fine of rupees 50,000, and in default of payment of fine to undergo simple imprisonment of 3 months. And similar under section 6. Now the question here is that though the punishment is same and it must have been or it has been written as they shall run concurrently. But the problem is, what about the payment of fine? The fine will still stand. And it was held by Honorable Delhi High Court that a person may not be punished twice for the same set of acts of commission or omission, which collectively constitute an offence covered by two different provisions of law. Though the law permits trial on alternative charge to be held for both the offences, but the punishment may be awarded only for one of them, and that too which is graver in degree or nature. So the trial can be there, the charge has to be first in alternative, and conviction can be there for all the offences, but the punishment can be only under one of the act, and if whichever is greater, if the POCSO is there. Similar case is the state of Gujarat versus Ashok Bhai, 2018, volume 4, Gujarat Law Reporter, 3184. Here the date of commission of offence was 25th of March 2014. The learned trial court sentenced the appellant to undergo imprisonment for 7 years and fine of 5,000, and in default SI for period of 1 year under section 4. And no sentence was imposed under section 376 on the ground of double jeopardy. Well, it was held by Honorable Gujarat High Court that the age of the victim was less than 16 at the time of commission of offence, and as per amended Act 13 of 2013, minimum punishment for offence under section 376, subsection 2, clause I is 10 years, but which may extend for imprisonment for the remainder of that accused natural life, and therefore punishment under IPC is greater in degree. It is not that POCSO has to prevail, but in which the punishment is greater in nature. And learned trial court materially erred in awarding punishment of only 7 years RI. So considering section 42 of the POCSO Act, the sentence was modified to 10 years RI under section 375, and no separate punishment was awarded under section 4 of the POCSO. Next comes the case of Independent Thought versus Union of India, very well-known case. Again, Honorable Supreme Court has held that section 42 makes it clear that where an offence is punishable both under the POCSO and IPC, the offender, if found guilty of such offence, is liable to be punished under that act which provides for more severe punishment. So it is not only under the POCSO, but which provides more severe punishment. And thus, considering section 42, where an act or omission constitutes an offence punishable under POCSO as well as IPC, notwithstanding anything contained in any law for the time being in force, the offender found guilty of such offence shall be liable to punishment under this act or IPC, which is greater in degree. Similar are the cases Bishal Lamgade versus State of Sikkim, Law Finder, document ID #785681. 376 2 and 4, same punishment, same fine. It was held since there is also an imposition of fine under section 4. For the ends of justice, I am of the considered opinion that the imposition of sentence only under IPC will adequately serve the purpose. The sentence of imprisonment imposed by trial court modified and confined only to the sentence under section 376 2I of the IPC. Next case, Siddharth Dagru Sonde versus State of Maharashtra, 2017, ELL MR Criminal 4192. Same proposition was there, and again it was held by Honorable Bombay High Court that imposition of punishment for both the offences is nothing but a legal error. Then comes Sagar Kuldi versus State of Odisha, Manupatra, Odisha 0745 of 2017. Similar facts, and again it was held to be a legal error. Then comes Vinay versus State of Delhi, Manupatra, Delhi 0885 of 2018. Here again, he was punished under section 354A and section 10 POCSO. For both the offences, same punishment was given to him, and he was held, modifying the sentence was held only under section 10 of the POCSO Act. Balaji Sarjirao Kamble versus State of Maharashtra, Law Finder, document ID #919738. Again, the Bombay High Court took the same view. Now the question. First question I would like to take up, it has been put to me that if sentence awarded is life imprisonment, and that life imprisonment has to go for the natural remainder of the natural life of that person, and fine has also been imposed. Now, in default of fine, it has been stated to pay such and such, to undergo such and such imprisonment. What is the fun of that? Very true that when life imprisonment has been imposed, fine has been imposed, life imprisonment till remainder of the natural life, then mentioning that in default of payment of fine has no fruits. It is a futile exercise because when the entire life he is there, then for what period he will be paying, undergoing the imprisonment for non-payment of the fine. Next question which crops up is whether punishment less than the prescribed under the act can be awarded to the accused. Again, here the answer is no. This is the very recent judgment, State of Karnataka versus Shak Rof Manupatra, Karnataka 0238, page number of 2023. It is settled principle of law and requires no emphasis that when a statute prescribes minimum sentence, the trial judge or the appellate judge has no discretion whatsoever to reduce the minimum sentence prescribed by the statute. So the minimum has to be maintained. And now under section 18, attempt to commit the half of the punishment. And these are the case laws which define what is half of life imprisonment. This is the Suresh Ilyas Pintia, Kashinath Kamble versus State of Maharashtra, Criminal Appeal number 272 of 2017, decided on 21st of September 22. In this case, relying upon sections 57 IPC and case of Chandrakant Vittal Pawar versus State of Maharashtra, 2011 SCC Online Bombay 1731, Honorable Bombay High Court has held that it means 10 years. Before coming to the part of the compensation, I'll just have a very little glance on that. The question one was put on the group is, what is the period of submitting the final report as per section 25 subsection 2 POCSO Act, particularly under section 4 and 6 of the POCSO Act. And connected question was, if final report not submitted within prescribed period in case of serious or heinous offences in the under the JJB Act, then what to do? Now, it itself also relates that the challan or the final report has to be presented according to the CRPC. So, section 173 CRPC is there. 173 subsection 1 capital A, though prescribes the period of 60 days and supposed to furnish the final report. But the thing is that if not furnished, then what? We know that if the challan is not furnished within the time frame, then the default bail, right to default bail arises of the accused. But the default bail is governed under section 167(2) of the CRPC. So it is well defined that for this such and such period, it has to be such and such period here has to be given. So we have to go according to section 167 subsection 2 for default bail only. And therefore, what it infers is that the time period has been prescribed, which can even extended. The repercussion is only the default bail, but default bail has to be dealt according to section 167(2) under the JJ as well as under the POCSO. Now coming to the compensation under the POCSO Act. I am just dealing in very summary manner. We all know that the CRPC section 357, 357A, and they deal with the compensation under the POCSO Act, section 33, subsection 8, and rule 9 of the POCSO rules 2020D. So what is that? If the accused is convicted, so compensation to be quantified by the court. It is well settled now that under the POCSO Act, if the conviction is there, punishment is there under the POCSO Act, the compensation has to be quantified by the court while considering the factors under Rule 9 of 3 of the POCSO rules. And recommendation to DLSA to pay that amount, which will be deposited in the bank account of the victim or joint account of victim and guardian within a period of 30 days. If not paid, even then the reasons to be assigned. There are a number of judgments that it should not go below the amount which has been prescribed in the victim compensation schemes. That is of Punjab is having separate, Haryana is having separate, Chandigarh is having separate, and there is one Nalsa. Almost they have mentioned the same amount. But if you want to go below that, you have to assign the reasons. Now, on conviction, if the court is not of the opinion to grant the compensation, even then the reasons have to be mentioned. On acquittal, there can be acquittal on two grounds. First, if you do not believe the version of the prosecutrix or the prosecutrix turns hostile, she does not support the prosecution version, then she will not be coming under the definition of the term victim, which is defined under section 2WA of the CRPC. To grant compensation, one must fall under the definition of the victim. So commission of an offense is a prerequisite to the rights of the person who has consequently suffered loss or injury. And if the acquittal is there due to insufficient evidence, the accused has been acquitted, but it has been held that he did not commit the crime. However, the offense has been committed with the victim. Then she will be falling under the definition of the victim and entitled to compensation. Again, then, as the things have to be followed on conviction for compensation, here the compensation must be paid to that victim. With regard to interim compensation, interim can be there at any stage after registration of the FIR. So please, I request every time that the FIRs, whenever the FIR is there within your jurisdiction under the POCSO Act, ask the concerned SHOs to send the reports to your courts as well, so that you can come to know that such and such offense has been committed, and if any suo motu action has to be taken, you can ask for payment of the interim compensation. And when interim compensation is granted, it has to be adjusted in the final compensation if granted in future. Again, this interim compensation has to be quantified by the court. Next question crops up, whether this interim compensation can be granted more than once. The answer is yes, only if there is change in the circumstance. Such circumstances are there that the previous interim already granted was not either sufficient and there has been change in the circumstance due to any medical or any other reason, then obviously and positively it can be granted more than once. Again, if the accused is acquitted due to insufficient evidence, she can be granted final compensation and the interim has to be adjusted. But if already given interim and she resigns, the accused is acquitted, no recovery can be there under the POCSO cases. Recovery can be there under the rape cases, under IPC, but not under the POCSO cases. Then, due to finding that no offense has been committed, the interim can be recovered by DLSA under Rule 13 of NALSA, Rule 9 of Punjab Victim, and Rule 13 of Haryana Compensation Scheme. So these are the case laws for relating to the compensation. That is the State of Chhattisgarh versus Dilip Verma and others, Manu Patra, /CG, Chhattisgarh, page number 0206 of 2017. Bijoy versus State of West Bengal, very popular case, 2017, Criminal Law Journal 3893. Nipun Saxena and another versus Union of India and others, 2019, volume 13, SCC 715. Then Rajkumar versus State, 2020, volume 266, DLT 179. So these are the cases related to compensation. We have done with the charge that the alternate charge has to be framed and identity of the victim has not to be disclosed during any stage of the trial. Though alternate charge has to be framed under the IPC as well as under the POCSO, the conviction has to be there under both the correlating offenses, but the punishment under Section 42 of the POCSO Act can be only in one of the provisions, which is graver in nature. And when conviction is there, the punishment is there. Punishment should not be less than the prescribed punishment, and the date of amendment and the date of commission of the offense must be taken care of. And while convicting, compensation must be granted. If not being granted, then reasons must be assigned. And even at the time of the acquittal, or even untraced report is there, accused is not found, then the CRPC provisions are there that the compensation can be granted to that victim because she still comes under the term of the victim. And even if the acquittal is there, she is held to be victim, then she is entitled to compensation. If not, if she is not found to be victim, she resigns, the prosecution story is not corroborated, it is not proved, no offenses made out, then obviously she is not entitled to. Interim compensation can be paid at any stage after registration of the FIR, and these special courts have to quantify the interim as well as the final compensation. So recommendation is only to the DLSA for payment of such amount. And the factors to be kept in mind, they are to be discussed. They are under Rule 9 of the POCSO Rules 2020. So these are the victim compensation scheme. And this was all about today's webinar. Thank you for joining at this hour of the day. Thank you so much.